Howdy, howdy. We're here to talk about the upcoming Michael Drake trial, which begins on Monday. And we have a legal expert joining us here in Tampa Bay. His name is Jay Hebert. You may have seen Jay before. He was our analyst on the Casey Anthony trial and did an amazing job for us on that. And he has also given us quite a bit of analysis since 2008, since this shooting happened in Clearwater. And so the reason we're bringing Jay in is because he is an expert in self-defense and stand your ground. And initially, you may recall, Michael Drake had claimed that he was going to, nope, you're right on time, we just started, that he was going to claim stand your ground immunity. What does that mean? Well, in the state of Florida, we have a very generous stand your ground law. And what it means is, hi Tari, we're talking about the Michael Drake case. What it means is that if you are in fear for your life and in imminent danger of being killed or severely injured, you can respond with fatal force. And then if you do that, Jay's watching, and as soon as I'm able to invite him, I will. You are entitled to defend yourself. I am in a private room. Yes. Hi, Jay. I just need to be able to invite you. So just like we did before, I have to be able to add you. So give me 2 seconds and hopefully it'll click in and let me add you. This is going to be a real interesting trial. I'm looking forward to watching it too because I think it's going to be a precedent-setting case either way. A lot of people are going to be watching this because of the Curtis Reeves case, which has been on hold forever and ever and ever. And ultimately that case, I don't want to get too far off track, but that case will have to be determined, I think, by the state Supreme Court because the law changed. So stand your ground law changed and it basically removed the duty to retreat. There used to be this duty to retreat. You had to at least demonstrate that you tried to get away from the person. Well, our legislature here in Florida said, wait a minute, we don't want people to have to retreat. We want them to be able to defend themselves and be alive. Starts on Monday. So the law changed. It took away the duty to retreat. It also put the burden on the prosecution, not on the defense, to prove that the person, which they always have that burden, but to prove that the person was standing their ground. The way that stand your ground used to work, and it's an immunity, not a defense, which is a little bit confusing. The way that it used to work is that you had to prove that you were standing your ground. Now it's they have to prove that you were not standing your ground in order for you not to be granted that immunity, which sounds like a lot of double negatives, and it is. So let me get Jay in here and invite him to the conversation because he says so much more eloquently because I see headline after headline calling this a stand your ground trial and calling this a stand your ground defense, which makes me want to pull my hair out and I'm a lawyer. The reason it drives me crazy is stand your ground is an immunity. That would have already happened, and it didn't for a very specific reason. So maybe we can pick that up right there. Because initially, everybody remembers stand your ground, stand your ground, stand your ground. Well, he was charged with first-degree manslaughter. He is having a self-defense case now. That is a defense because he didn't go for stand your ground immunity. So we should probably start by talking about what that is, because people are entitled, if they want to claim stand your ground immunity, to that hearing where they can go before a judge and ask the judge to grant immunity, meaning the judge says, yes, you're immune, you're out the door, and you're not going to be prosecuted. And that's not what happened in this case. But we in the media are so fond of that phrase, stand your ground, that I continue to see it perpetuated to the point where I might need therapy. Because it upsets me, because it's not exactly factual. So let you talk for a second about that.
Well, it's great to be here. I'm glad we've worked through all of our technical issues, and it has been an interesting morning, and this is an incredibly interesting case. You know, one of the reasons why stand your ground gets kind of looped into this situation is when you, and your recitation of the law is very factually correct, and you've done your homework.
Thank you.
Number one, it is an immunity motion. It is a motion that says the defendant is immune from prosecution because on the basis of the evidence that is presented to a judge, no jury, you file a motion for stand your ground, which I filed the first one in the history of the state of Florida. And just for your listeners, the background of stand your ground really came out of the hurricanes that we had in 04, 05, 06, where Jeb Bush basically came in and said, hey, if you're in your home, you can protect your home under the castle doctrine, but if people are looting your home and you're in your front yard, you should have an ability to stand your ground. That's where it all came from. So
it kind of extended the castle doctrine.
It did. It's exactly what it did. It basically added the language that you no longer have a duty to retreat. You always have the right to defend yourself. You always have the right to justify use of deadly force, but you had a duty to retreat when you were outside. So that's really the key element that's here. What is interesting about why stand your ground kind of comes into play is when you look at the justifiable use of deadly force jury instruction, it specifically says that a person has the right to prevent imminent death or great bodily harm to defend himself, and the additional language is added if the defendant had a duty to retreat and had a right to stand his or her ground. So that's kind of incorporates the no longer duty to retreat process that's in the instruction.
Mm-hmm.
But the immunity motion is a completely separate animal, and for tactical reasons was not used in this case.
Right.
And I can talk a little bit about why those things happen.
Yes, let's start with that, because I think it'd be really helpful for people, because they keep seeing these headlines that say stand your ground. This guy's team, as you very well know and as I know, is putting on a self-defense case. They're not putting on a stand your ground case for very specific reasons. Yeah. Let's talk about that.
Well, with the stand your ground, it's a pretrial motion for immunity, and a judge, not a jury, makes a decision. What happens is you have to, especially in these situations, have the defendant, in this case, Mr. Draco, would have had to probably testify to talk about the fear that he was in and the threat that he was under and why he did what he did. So you always run the risk of having your client testify and that testimony now being out there. There's still a Fifth Amendment right that carries on to trial, but there's evidence that can be garnered from that. And it's an interesting legal issue that has kind of evolved and changed since the law has actually morphed, because the original stand your ground, the burden was on the defendant to prove, and the legislature went back, and I think correctly went back and said the defendant shouldn't have to prove anything. So that's number one.
Right.
Number two, you also give the prosecutor and the judge a preview of where you're going. You're laying out your roadmap.
You show
your hand in the hopes that the judge will take the case and the facts and give you the golden ticket, which is you're not being prosecuted. Where the stand your ground immunity cases are most successful are in the pre-file decisions. Before the government files a charge, like in this case, the manslaughter, we're able to go in and say, look, this is why, Mr. or Mrs. Prosecutor, this is why this should be a stand your ground case. And they look at it through that microscope, and they make a determination that it probably would result in immunity being granted because of the facts and circumstances. That's different than the movie shooter theater case. That's different than this case. So in this situation, you know, this area of law is raising a level of discussion, which is why we're having this conversation. And it's important. It's an important discussion, especially now in the political climate we live in, especially with guns and all the other issues that are kind of filtering through our legal system in the world we live in.
Sure.
You know, there are people that feel very strongly about the Second Amendment that always want to carry their guns. And I certainly understand that. And I certainly respect that. In this world where you walk into a Walmart, or you walk into a movie theater, you walk into a convenience store, and you run the risk of being shot, it is the reality of the world that we live in. And we see a lot of copycats. We see a lot of people that will read these laws and are carrying their guns. And again, that's a Second Amendment right to do that. He had a concealed weapons permit. That's not an issue. The real question will be was that force that we see, and in this case, it does not happen very often, we have the best evidence. We have a videotape. Was that force, and did that put him in fear of death or great bodily harm? And that really will be the issue.
And pushing you and then retreating is what the investigators found when they looked at the evidence and they looked at the distance. I remember the distance being extremely important.
Huge.
It was much less what's the best word I can use? It favored the victim when you looked at where he was hit, the position of his body at the time that he was hit. Like, they found that he was, as I understood it, and I read this, the investigators wrote that he was in a posture of retreat. So he was in the middle of trying to turn and leave the situation. So it's very hard to go into a stand your ground immunity motion for immunity when your victim, according to investigators, was found in a posture of retreat. And also, when we started to get into this, I want to make sure we tell people this. Once he was charged with first-degree manslaughter, that's when they made that decision to say, okay, we're going to go for self-defense because now we're going to trial. The pre-trial motion would have been to claim immunity. And I think his legal team made a decision right then and there, and agree with me or disagree with me, that, hey, we've got a much better shot at arguing self-defense. We don't have a stand your ground claim on our hands here.
Well, and I think that for a number of reasons they made that decision, but you're absolutely correct. They made an elective decision strategically that they're better off with jurors making a decision about what happened that day and whether he was justified in the use of deadly force. But let's talk about the video. I mean, it's what captures us all. It is the best evidence. Yeah. So when you look at it, number one, and I've looked at this video a lot, and I've looked at this video with experts. I've looked at this video with a threat matrix expert who teaches deadly force threat matrix at the police academy. So I've had opportunities to look at it from different views. Number one, we know that the victim, Mr. Glaucon, when he walks out of the door, he doesn't really know what's going on. Obviously, he sees something. The first thing that happens,
a conflict between his girlfriend and the
and we don't have any sound, so all we have is visual. We don't know the level. We don't know the language other than what's been repeated in testimony, but we don't know from watching the video, was it cussing, was it screaming, was it aggressive? So we have verbal issues that are going on. And it's apparent, it's clearly apparent that Mr. Draka doesn't really even see him until the very last second before the shot. You can see his head turn quickly, and that's when it happens. Now, from that point, if you put a stopwatch on it, it's just under 3.5, 4 seconds of time before the shot's fired. That quick. So let's talk about a couple things. Two things are critical here. Verbal and nonverbal behavior. And this is where people start talking about verbally. When somebody comes at you and gets into a fighting pose, that's a nonverbal aggressive position. He goes to the ground. If you talk to law enforcement officers, they will tell you that there's a zone where they're always at risk, and it's, it can be as many as 20 feet, but we know for certain within 12 feet, there's a zone a zone of contact where it is literally a split-second threat matrix decision. Then, in addition to that, if you talk to law enforcement, they will tell you one of the worst positions you can be in to defend yourself is on the ground. The person coming at you has an advantage because you're on the ground. Now, if he had pushed him and he had, ran off or tumbled off, didn't fall but stumbled off, being on his feet, he's in a much better position from that standpoint. He's on the ground, so he has that situation occurring. But when you watch this video, there's a critical piece of evidence. I think the jury is going to put a lot of emphasis on this when evaluating this case. There's a moment where the victim in this case, and certainly I don't think anybody feels that he deserved to lose his life, and I certainly understand that. It's horribly tragic. But there's a moment where he pulls his pants up right before, when he's still moving forward. And to me, that nonverbal communication it's go time. That if I was arguing this case on behalf of the defense, I would look at that and say, when you're pulling your pants up, you're telling that man in 3 seconds or less, I'm coming, and it's go time. And if
you're not saying I don't want to strip over my pants,
I don't think so. I think you're saying
I'm playing prosecutor.
I appreciate that. Sure, and both sides will interpret it accordingly. But if you look at and slow down that one little area there, That's the point in time when he reaches into his pocket, and obviously he's got his gun ready to go. It's loaded. There's no question. He doesn't have to.
Great.
Yeah, he doesn't have to.
The victim in this case was unarmed.
Unarmed.
We need to make that
for
clear.
sure, and we know that from the evidence inside the store and outside the store. Defense has even conceded that. So,
right.
But the key, the absolute key is, was that force used enough to cause great bodily harm? Now,
getting shoved, is that going to kill you?
Right. Well,
maybe. If you hit your head a certain way,
those are all the arguments. If you were a prosecutor, and my oldest son just started with the state attorney's office last week, he may prosecute a misdemeanor battery. A misdemeanor battery is an unlawful touching against the will. It can be as simple as just coming along and tapping somebody, or we see in domestics where things are more aggravated. Then we get into aggravated battery and felony battery. So what level of force was used? And I would dare say that shove probably may not be a misdemeanor battery. It might be a felony battery. I don't think it would be an
without a weapon.
I don't think it would be an aggravated battery. So we have aggravated batteries, or when weapons are used or serious bodily harm occurs. Whether it's a felony battery, that's going to be a tough call. But it's clearly not a push. It's a clear shove. Now, in the situation with Mr. Clark, you have a victim who also may be defending his girlfriend. So he's walking into that situation, and he has a right to defend her. Yeah, and so you've got children in the car. You've got a lot of factors that come into play in what ended up being a perfect storm.
Let me ask you a couple questions, because people are posting questions for you, and I promised them that I would relay them to you. A lot of people are asking this question. I think it's an excellent question. In a self-defense case like this, does it matter who started it?
It really doesn't, because it's going to come down to the very specific details of the event itself. And what we have here, by sheer luck, is the video. And this case will be won or lost based on what those jurors are able to look at and their interpretation, which leads to kind of another issue, is what types of jurors are they going to be looking for? A lot of times in a case like this, you might look for somebody that would be, say, fairly liberal or, anti-gun. But I think in this situation, they're going to be looking for pretty conservative people that go, hey, we think you're able to carry, and we think you're justified, and we think you're going to do that. If you're a defense attorney, if you're the prosecutor.
I would say this though, Jay, let me throw this in there, because we've had conversations, a ton of them on Facebook Live with our audience, and many of whom are CHL carriers. And many of them have said, hey, I carry a concealed weapon. I went to the class. This is not a circumstance where you should pull out your weapon. A number of them have immediately said, I watched this. That is not what we were taught to do. This guy was not in imminent danger of being killed or maimed or disabled. And those people take it very seriously, because they look at a case like this as a potential threat to their ability to carry a concealed weapon, which people are very concerned about. They want the right to do that. They don't want some goofball, as they've called him, going off and messing it up for everybody else, also making kind of a bad name for people who are carrying concealed weapons, as if these are a bunch of cowboys who are out there in the Wild West thinking that they can commit vigilante justice left and right because somebody shoved them in a parking lot. So I would argue that you might want a CHL carrier on that jury to look at this case and say, wait a minute, And now we're talking about, I think, different sides.
Sure. And everybody thinks that jury selection is about picking the right people. When I teach jury selection, we talk about jury elimination. You know that they're going to love these people, and we're going to love those people, and none of those people are getting on a jury. So what you're really left with, when I teach it, we talk about give your favorite ones a 1 and your least favorite ones a 3. But we're going to probably end up with a bunch of 2s. So we rank them 1, 2, and 3. And we
Who's in your strike zone? Who's in your strike zone if you're the prosecutor?
If I'm in the prosecutor, I am asking questions about how do they feel about bullying? How do you feel about attacking? How do you feel about, because people that will say, look, he's much bigger, he's much smaller, physical differences, those kinds of things. I would really kind of jump into, and jury selection is about planting seeds. It's about trying to plant seeds that later you're going to reap in the course of your trial, either through cross-examination as a defense attorney or in closing argument. So you want to put things into the jury's minds to start making them see your case. You can't try your case, but you can certainly win your case in jury selection by getting people. And the biggest thing about either side is not yes or no answers. You want to know how they feel. I would teach it all the time. How do you feel about guns? How do you feel about somebody defending themselves? How do you feel about?
So it's philosophical.
Yeah, it's trying to get into their ideology about why a person carries guns. Somebody goes, you're never justified. You can't take another person's life. You should never be able to do that. Well, if you walk in and a child of yours is being sexually assaulted, are you going to defend that child? Or if your house is being robbed and somebody puts a gun in your face, are you going to? So you start there and you start peeling the layers back. And I love to get jurors talking. Well, listen, Katie just said this. What do you think about this, Jay? What do you think about what Katie just said? And get that conversation. This could be a very lively jury selection if done correctly. To really bring up the emotions. Yeah, and to speak the truth, as they say, which is what voir dire stands for. So it's going to be an interesting process, I can tell you. So what else do your listeners have to ask?
Yeah, lots of good questions. And as I was listening, I was taking them down. Someone brought up, and I thought this was a great question, the issue of the parking space, which was marked for a person with a disability or a handicapped marked parking space. That was what the defendant said enraged him, that this car, which didn't have a placard, was parked in that space. We know that there were people in the car, so whether the car was parked or not will probably be something that will be talked about. But that is what kind of triggered this person to be upset, and we don't know because we can't hear, but there was some sort of exchange of words, ideas, probably some expletives, right, before this. Is that a factor? Because when this happened, I'll tell you what, Jay, it was interesting. A lot of people were really ticked off about someone parking in a space that was marked for a person with a disability who didn't have a disability. And even though someone lost his life over something that trivial, it does strike a nerve with people. So are you going to ask questions about, are you related to someone who uses a parking space and a placard because of an injury or disability?
Well, it's interesting, and it's a great question by your listeners because it does strike at the core for a lot of people, especially people that live it and experience it. And I had my hip replaced a few years ago, and I got a temporary one. And I was very reluctant to use it because I felt so badly that I might take a space for somebody that really needs it, and it's never come out. But you see that, and people that live that, I think it is a relatively minor issue, but it has a very significant underbelly. But here's what's interesting. When the victim walks out, when he comes out, he has no idea what the argument's about. There's no indication that he knew that it was about the parking.
It was about the parking.
Right. So I think the government is going to kind of try to limit that to a certain extent. He just saw a verbal confrontation. And again, was there cussing? Yes. Was there language? Yes. Was that, again, when your significant other is being berated by somebody, you're probably going to step in it. And he's a bigger guy, and he didn't know what he was walking into. So I think that's important. One other thing that we know of. One other thing that's interesting, though, and I don't know that your listeners know this yet, and if they haven't looked at the guts of this case, his girlfriend, who was having this confrontation, you can see out in the videos getting out of the car, she told law enforcement immediately after the shooting, while it was all being, one of her statements was, he assumed a fighting position, that he kind of got into a fighting position. I think that statement is going to be a huge nugget for the defense. if I was doing an opening statement on behalf of the defense, I would come out and say, he assumed a fighting position. Those aren't my words. Those aren't the words of the prosecutors. Those are the words of the victim's significant other.
That's going to be tough for her.
Yeah.
That's going to be an
Yeah.
emotional thing for
And
her. She's going to feel like she's something to somehow excuse this, and she's got a dead father of her children on her hands.
And that's the part we don't lose.
Go
ahead.
Oh, no, you finish.
And that's the difficult part. Like you said, like we started talking a few minutes ago, it's a tragic case from start to finish. It really is. And I certainly understand why the sheriff had a hard time making that decision.
I think he just wanted to stay the heck out of it. That's my 2 cents as a reporter is, if I'm a sheriff, I'm going to let the people who have to make those choices make those choices. I'm not going to play prosecutor. Yeah. Nobody elected me to be the DA or the ADA. I'm just the sheriff. I think that was a very smart decision by him, because you're damned if you do and you're damned if you don't, right? Yeah. You could somehow influence the outcome of a case if you take a position either way. So by staying out of it and saying, I'm going to let, the people who are in the office to do this, do their job, I think was very smart on his part. And if I were advising him, if I were his imaginary lawyer, since I went to imaginary law school, I would tell them that. People are asking about the venue and the population of the jury. And I'm going to add one other thing to this, because it always comes up. We have a black victim and we have a white defendant, and we've got a dead black victim.
Yep.
The role of race in a case like this can't be ignored.
And
I think it will be effective.
I think it would be insensitive, and it would be factually incorrect not to consider that. And that's going to be an important part of jury selection, to try to get people to put on their blinders and judge it based on the facts and the law, which is what a courtroom should be. That's why the scales of justice are blind.
In a perfect world.
But the reality of it is, it will be an issue. You will see the victim's family will be there every day. They may be wearing matching. I've had this happen in trials I've been involved in, matching shirts or outfits or support bands or whatever. And certainly understand that. It will be charged. It will be a charged environment. Walking in and out of this courtroom for everybody will be a difficult thing. There'll be extra security there. So all of this will be important. I do believe the change of venue, there's been a lot of publicity about this case. I wouldn't say it rises.
Let's talk about that.
It doesn't rise to the level of Casey Anthony, which would be, this is why we picked our jury here and then tried the case in Orlando. I don't think it's risen to that level. I don't know that Drake's name is ringing a lot of bells. Stand Your Ground convenience store rings a lot of bells. So we're going,
which is why it gets the headline, even though this is a self-defense case.
Right. And so I think what's going to happen is when we qualify juries, we've got to get through the first phase, which is the pretrial publicity. How long can you sit for? I don't think it'll be a long trial. It's really not a complicated case in the sense that there's.
Are you going to have a jury that hasn't heard of this case? I mean, you're in the backyard of where it happened, right?
Yeah, I think you're going to have people that are aware of it, and they're going to do what jurors do, which is, I'm aware of it, and I can still be fair and impartial. I'm not affected by the media. I'm not affected by that. And that'll be the critical inquiry that Judge Ballone, Judge Ballone's handled a lot of these high-profile cases, extremely good judge. The prosecutors in this case, Fred Schaub and Scott Rosenwasser, are two of the best prosecutors in Pinellas County, veterans, seasoned guys that know exactly what they're doing. They will try a very surgical, streamlined case, almost Joe Friday, just the facts. They're both passionate, but they're very, very organized. They'll be, and their case will be very streamlined. And then you have the defense team, which is kind of a mix of different lawyers that have kind of come together. My understanding is a lot of them are doing it pro bono. And it's a mix. I think there's 4 lawyers that are still on the ticket. One lawyer is no longer practicing law because of the Florida bar issues that she had. She's gone, Lisa Clifton, which was a good thing. And I think that's how all these lawyers first.
She was soliciting.
Yeah, all these lawyers first came together through her efforts. and I believe it or not, a Facebook post, is what my understanding is. So, but John Trevino's been around a long time. Brian's an excellent lawyer. These folks know what they're doing. So I think the entire country will be watching this. And the primary reason, if there was no video, this would have been a back page story at the end of the day.
When you look at Pinellas County and you look at the pool of jurors that they're going to have to choose from, one of the issues, and I hate to bring race into this again, but I do think it matters. One of the issues in any case like this is going to be, is this a jury of this person's peers? Not just on the part of the defendant, but on the part of the victim. So if you have an all-white jury, can you have a fair trial? And can there be issues that may arise where you have vulnerabilities when it comes to the appellate process down the road? Does that open things up in any way down the road to an appellate lawyer getting a hold of this case and saying, wait a minute, we're assuming, let's say if there's a conviction, this is a for instance, not a prediction.
Yep.
Because I think this one could go either way. I could see this guy walking, especially in this particular county. And I think you will have rioting in the streets if that happens too, because people will feel like that someone who is African-American who is shot and killed unarmed by a white guy in Florida, doesn't matter. That will be the outrage that people will feel, understandably. When you look at the makeup of juries in Pinellas County, are you going to see enough black and brown faces to put together a diverse jury so that you have a process that people can have confidence in? Because what happens inside of a courtroom influences what happens all over the country. We see this all the time. 2016 is a great example, right?
Sure.
So we saw all of these cases where we had African-American people who were shot, in some cases by police, in some cases by people who were playing the police or wanted to be the police. And when those people walk, it sends a terrible message. And you have all of this racial division and all of this feeling of, the Black Lives Matter movement came out of that, right? That, everybody's life matters.
Yep.
In Pinellas County, can you get that kind of jury, a diverse jury, so that when there is a verdict, it's a verdict in which people of color can have confidence?
It's a great question. You want to be cautiously optimistic that can happen. Under the state of Florida jury selection rules and laws, you have to give a race-neutral reason to excuse somebody of color, or a specific reason that, hey, look, they're NRA and they're pro-gun, they're pro-this, or they can't be fair and impartial, or they have family members who have been killed. You have to give a race-neutral reason if that issue is raised. Unfortunately, we know what percentage-wise the racial makeup is in Pinellas County, but then that percentage is not reflected in the jury pool. Unfortunately, a lot of folks don't come to jury duty. They blow it off, or they won't be able to do it. Or
if they're not registered to vote, and that's so important. When you talk about get out the vote, and this rarely comes up in the media. We talk about get out the vote, and we talk about minority communities encouraging people to be voters. One of the reasons that these organizations encourage people of color to be voters is because then you're going to be on jury duty. You're going to get that notice in the mail. And why you tend to see unbalanced juries is very much for that reason. So that's something that people may not understand. It's like, well, if you have an all-white jury, it may be the result of this is who you had to choose from, and you can't create people who aren't there.
I would imagine
that's a tough.
Yeah, and I would imagine that Judge Bologna's probably ordered 300 jurors, and it will be interesting on the first day, and they'll probably take them 100 at a time and pre-screen them on certain things. And so I we'll have to wait and see how that all plays out. But the Ferguson situation, the things that we saw and went through in St. Louis certainly are a microcosm, and you're right. And I hope and pray as a citizen here, as a member of this community, that we will let the law work itself out. I agree. One way or the other, somebody's not going to be happy on one side or the other, and we get that. But the hope is that it's a fair trial. The appellate issues, yeah, it's always a risk. It's always going to be in play. I would imagine of the 4 lawyers, one of them must be there simply to make sure that the record is preserved for appeals and issues. The other thing that can happen in a case like this is we can see some new law being created. The law is constantly changing on the stand your ground issues. I was one of the first file first appeal on a stand your ground case because we had to make some changes. It went up and Tallahassee listened and it got done. So yeah, I think it's always going to be in play, and it's going to be another interesting week here in Pinellas County. I mean, we seem to have a never dull moment, and but it's important. The only thing that I was always curious about in this case, and we didn't really talk about this, I was kind of surprised that a grand jury wasn't convened. Now, I trust Mr. McCabe. He's been the prosecutor in this county for a long time. Before him, Mr. Russell, we've only had 2, and the continuity of this office and the professionalism is a model for the entire state. It is a pleasure to practice here, and they're good lawyers and they're well trained, and I'm proud to be part of this. I'm proud to be part of this legal community. I thought that it might be a good question for the grand jury to decide, but they sat down with their homicide committee, and like you said a few minutes ago, took it out of Bob Galtieri's hands, who is a lawyer and a sheriff, and a good one, and a good friend, and a guy that let Mr. McCabe and his staff and his homicide committee make that decision. So I respect that. I think it might have been easier for him to turn it to a grand jury and kind of pre-try the case, but they made their decision, and now we're going to see what a jury does next couple of weeks.
My guess, and this is my untrained, just journalist guess on that, because I was interested in that too. I think they didn't do that because there might have been a no bill. And if you got a no bill, it might have the same impact as a not guilty verdict in this case. Yeah. And you could have rioting in the streets and people feeling, just devastated and as if they'd been denied justice. And I think that's probably why they didn't do that. Would that ever be a reason? Is that not?
I think you should have been a lawyer, and your assessment is spot on, as you have been throughout the entire process that we've been talking.
Oh
no,
stop.
it's very impressive. First of all, to see judicial and journalistic integrity, but also good observations from start to finish. And I think that's a big part of it. I think that was a decision that they'll live and fall with whatever jury says. And I think that's part of the process. Let me pose one last question, then I've got to get to the airport. Yes.
Okay.
How would this case turn out differently if the man was in law enforcement getting out of his squad car to write a ticket for that parking violation? Ponder that issue, and hopefully your listeners will ponder that. Imagine what would have happened and what would have been the response to, because we're seeing more and more we're seeing this water thing where people are throwing water on law enforcement. Well, that's not really deadly force. It's out of control. And I'm not saying that people haven't been mistreated by law enforcement. I've seen it, and it happens. But think about that. What would the legal outcome be if he was there? Now, he would have had a different duty. He would have been enforcing the law, all the above. But I can tell you, I've talked to a lot of officers, including people that train, and they said he probably would have unloaded the entire clip, not just one shot. I mean, under those circumstances. And
he didn't put a police officer, though, and that's so important.
It is. I mean, I'm posing a hypothetical for people to just contemplate. Yeah. And, when you have folks that are watching this, they're in tune and they're on one side or the other. Very few are, kind of holding their breath to wait to see what happens. They have feelings one way or the other about this case. Mm-hmm. And I think you're right. It could go either way. And either way, people are not going to be happy at the end of the day. And the concern and what we need to do, and I think what we as in the media need to do, is we need to encourage the system to work and to respect the verdict. I have always walked out of every courtroom, win, lose, or draw, and said, we respect the verdict. Maybe not agree with it, but respect the verdict.
You thank the jury every time.
Every time.
Thank the jury every time. Service, tough job.
Yep.
I hope they will look at the facts and be impartial. I think the video evidence, I agree with you, is everything. I also think, though, the analysis by the homicide investigator is critical
Yeah.
because they talk about where that bullet went and the
Yep.
turn.
Yep.
I think the turn is going to be a huge moment
Yep.
in this trial. I think you're going to see a lot of emotion when that happens,
Oh, yeah.
but I think more importantly, you're going to get people's attention. There's no way that this jury is not going to be put in a position to really think about the facts of this
Yep.
case. And if you're prosecuting this case, I think it's much more about facts than emotion. If you're defending this case, I think it's much more about emotion than facts.
Yeah. And time, 3 seconds.
Boom. Yep, that quickly.
Yeah.
That quickly.
Yeah.
It's shocking. We have to, as you know, redact some of that video for sensitivity
Sure.
reasons because we would never want to show something like that on television. But when you watch the unedited version, which the jury will see and they'll see it slowed down, it catches your breath. I mean, it is emotional to
It
see
really is.
that happen to a human being. Yeah. Jay, thank you so much. I could talk to you all day long. Let me ask you one
Sure.
favor. These folks posting here, they're asking a lot of questions. I'm going to do my homework and try to answer all of them. But if you have answers, get on there, post your answers, because they want to hear from the horse's mouth too. So I know you've got a long flight.
I do.
If you have Wi-Fi on that flight, God bless you.
It's Delta, and I will check in on it, and I will be happy to respond. And normally I'm not wearing a baseball hat and a T-shirt, but like I said, I'm headed to TIA in a few minutes.
You know when you know a successful lawyer?
What's that?
When he's not dressed like a lawyer because he doesn't have to.
There you go.
That?
I like it. All right. Listen,
Thanks,
have a
Jay.
great day. Thanks, guys.
All right. Bye.